Good afternoon. Thank you all for coming. I'm Steven Kaplan, Director of the Stigler Center. We're very happy to host Nell Minow and Steven Kaplan for a conversation moderated by Luigi Zingales on the proposed new SEC rules and the future of corporate governance. Thank you all for joining us. Before we start, please note, we are on the record and live streaming, so please silence your phones, but feel free to share on social media. As usual, views expressed by our guests are their own, not those of the Stigler Center or the University of Chicago. As you may know, the Stigler Center promotes and diffuses research on regulatory capture and the various distortions that special interest groups impose on capitalism. We have many initiatives, including our podcast, Capitalism, co-hosted by Luigi and Kate Waldog, and our online publication, promarket.org. So please check them out. There are some of our upcoming events that I'd like to highlight. On January 24th, we will host Steve Kaplan again. Thank you, Steve. For a conversation with Emmanuel Saez and on his new book with Gabriel Zuckman on US tax policy and inequality. Then on January 28th, we will host a discussion at Bleacher with New York Times editorial board member Benjamin Applebaum and Booth professor Eric Hurst on how economists shape our world. And finally, on January 31st, we will have our Stigler Center open house here at Harper in Suite 217 over lunch. Come meet us and learn about all that we do. We'll also have food and swag for you all. Please make sure to sign up for our events before they sell out. Back to this afternoon. We look forward to an engaging conversation. Before we begin, please allow me to briefly introduce our guests. Steve Kaplan is the Neubauer Family Distinguished Service Professor of Entrepreneurship and Finance. He's also the Casimir EP Faculty Director at the Proxy Center. His research focuses on issues in private equity, venture capital, entrepreneurial finance, corporate governance, and corporate finance. He is the co-creator of the Kaplan Score PME private equity benchmarking approach, and he co-founded the entrepreneurship program at Booth, among many other achievements. Nell Minow is the Vice Chair of ValueEdge Advisors, which advises institutional shareholders on corporate governance issues. She has worked in corporate governance and shareholder advocacy for more than 30 years. She was the co-founder and board member of GMI Ratings, formerly the corporate library. She has also served as principal in the governance investment firm Lens, where Business Week called her the queen of good corporate governance, and Fortune called her a CEO killer. She has held many other positions and has received several accolades for her contribution to the field of corporate governance. Our moderator today is Luigi Zingales. He is the Robert McCormack Professor of Entrepreneurship and Finance and Charles Harper Faculty Fellow at Booth. He is also the Faculty Director of the Stigler Center. His research and interests span from corporate governance to financial development, and from political economy to the economic effects of culture, among others. He has written several books and appears frequently in the media. And now, please join me in welcoming our speakers.
So, thank you for the introduction, Simone. First of all, I would like to recognize the fact that we're very happy to have here the father of Nell, who is the former chairman of the FCC, and also the person who hired Barack Obama in Chicago and introduced Barack Obama to Michelle. So, I have actually been knowing Nell for many, many years now. I'm embarrassed to tell many. And I always like the lively in which she debates. And I thought she was the perfect person to debate with Steve on the issue of corporate governance in general. And so these two guys are the opposite end of the spectrum, because she complains that CEOs are overpaid, and Steve complains that good CEOs are underpaid. So I think that you cannot get people more far apart. But what we want to discuss today are the changes that the SEC is proposing vis-a-vis the way in which shareholders vote or are advised to vote. And this is actually a very important topic, is as important as vote suppression in democracy, is about who can get to vote and what opinions are expressed. And I think it's very important, especially in the business school, to debate these issues. So I want to start actually by giving you a bit of a background, because I guess a lot of people, even our students, don't know the intricate detail of how directors are actually appointed and how motions are proposed or dismissed at the level of corporation. So let me start with Steve, who has been and is a board member of many important corporations, so he knows firsthand, not only because of his study, but also firsthand what it means to be directors and how you get elected. So Steve, how do you get elected as a director in a company?
So it starts with a nominating committee generally these days, that the nominating committee of the board decides who they want to nominate as a director. There has to be an opening. And then, it's basically the chair of that committee, committee members, they get input usually from the CEO, they'll get input from board members. They often these days hire an outside search firm to help run it. And so somehow, some way, you get nominated through that process. And the process used to be more the CEO picked it. It's now much more a search firm and the nom and gov committee.
You're welcome.
But, thank you, you're very good, and thank you. And then once you are nominated, then it goes in the proxy statement. And the proxy statement comes out, and then at the annual meeting, which happens sometime after the proxy statement comes out, shareholders vote.
And can they vote what?
They vote whether to elect, do they vote yes or no on the slate.
Okay, so there are no alternatives. They vote yes or no.
They vote yes or withhold, and even a 99% withhold vote does not stop someone from serving. And in one company where all 9 directors failed to get a majority support, they handed in their resignations to themselves, turned down the resignation, and continued to serve. So
that may have been true in the past. These days, if you get more than 50%, you get more than 50% withhold, the evidence is pretty clear. Those directors end up often not being there. I think it's a little, there are always exceptions, and Nell will always point to the exceptions, but the general rule is that they're.
Okay, so
yes,
Steve, later we're going to ask you for the reference for this. So now you've been on the opposite side. You've been outside of the gate, trying to get in and trying to nominate directors. How difficult it is to nominate somebody who does not belong, can we say, to the old white cloud?
Just about impossible. And Boy is correct, as you know. There are boards that have one woman and say, we're good, we don't need any more women. So that it's very, very difficult. As I said, I love testifying before Congress on this because I say to them, you guys understand what elections are. Let me tell you what that word means in the context of corporations. There's no way to vote no and actually keep somebody off a board. At this point, I should mention that I once recommended a vote against my father, but he was an excellent director, just missed too many names at that company. So, but nevertheless, it's almost impossible to replace a director. And in fact, in the Dodd-Frank legislation, which came through after the financial meltdown, and which had a lot of things people have been asking for a long time, one of the things that got dropped was the idea that if directors don't get majority support, they should not continue to serve.
So we've talked about directors.
That's actually a reasonable position to have.
Okay, so we agree on something. That is a great thing. But let's move to other proposals. This is if you are a shareholder, let's say you are a shareholder of Walmart, and you think that is right that Walmart don't sell automatic guns in its stores, and you want to sort of propose this. How can you get this implemented as a sort of a simple shareholder?
So if you have at least $2,000 of stock under the current rules, you can submit a shareholder proposal.
Okay.
And then there's, again, it goes in the proxy statement, there's a vote.
So does it go automatically in the proxy statement?
I am not certain about that. Nell will have a better, Nell will tell us.
Okay, and
Does
then...
it automatically go? I mean, that's actually, I'm not.
First of all, the topics are very, very limited. You can't just have a proposal saying, you're making too many blue cars, you should make red cars, or you should make more fuel-efficient cars, or anything like that. That's called ordinary business. You can't have a shareholder proposal saying, you fired me and you shouldn't have fired me. That's personal. So it's very, 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 very restricted what you can have a shareholder proposal on. And also, you're limited to 500 words. And one proposal got kicked out because they had the word proposed, which made it 501. So companies will spend a lot of money on their lawyers challenging these proposals and are often successful. So for that reason, savvy shareholders will use tried and true proposals and use them as kind of a foot in the door to get conversations going about issues they really care about.
Because actually, all this is reviewed by the SEC, and the SEC decides whether it is a usual business proposal, as now described. If the proposal is to interfere in the usual business, then cannot be put to vote, so only kind of a generic statement can be put to a vote. And my example of Walmart was not a fictitious example. Actually, a church tried to get this to vote, and the Walmart blocked, and then they went up to, I think, the district court, and finally the district court said that the shareholders had no right to make a proposal of that type. So I think it's very limited what you can vote. But then how do you imagine that I pass all this hurdle, I get my shareholder proposal in front of the shareholder meetings. How do you campaign? And it's just, we're used to election, political election. What is the, in a business, what is the business campaigning?
So, first of all, it shows up in the proxy statement, so assume it gets on the ballot. It's in the proxy statement, so at that point, all shareholders are looking at it. And this is where the proxy advisors have some impact, because the proxy advisors will come in and make a recommendation. And then how do you campaign? If you're, if you are for this, you would presumably contact shareholders, and you would basically explain your case.
So if you are management, you can use company's money to campaign on favor of the opposition. If you are the opposition, you have to do it on your own.
I believe that is correct.
Yeah, I once got a phone call from a proxy solicitor paid for by the company trying to get me to oppose a shareholder proposal, and I said to the proxy solicitor, do you have the proposal in front of you? And they said yes, and I said, who is the proponent? And it was me. So, yeah, generally speaking, 99.9% of the time, the matters on the proxy are what we call routine. Nobody has to campaign for anything. And the proxy advisors, who of course are expensive and sell their services only to sophisticated financial professionals, over 90% of the recommendations are to vote according to management.
But so what is the role, because this is where we're heading to, what is the role that proxy advisors play in this game? And why this role is so crucial?
Proxy advisors really only came around in the 1980s, the late 1980s, and I was around when the first major one started, Institutional Shareholder Services. And the truth is, we were trying to start a different business, and we were completely unsuccessful. Everybody that we met with said, that's a terrible idea, don't do that. But we really could use some advice on proxies, because for the first time, anti-takeover provisions were coming in. Shareholders were being subjected to horrific abuse by both what we call raiders, now we call them activists, and by entrenched management. And they said, we're under a lot of pressure here. And in fact, it's important to remember, as we talk about proxy advisors, that there was tremendous corruption in the system at that time. And it was documented that, and Jack Bogle, the founder of Vanguard, wrote about this, that when portfolio companies would do things that were contrary to shareholder interests, but might give you 401k business down the line, you would switch your vote. And in one dramatic example, Deutsche Bank got $1 million payment from Hewlett-Packard and switched their vote from one to the other. So it was very difficult to try to get portfolio managers, investment managers, pension fund fiduciaries, even though they're subject to the highest standard of our legal system, fiduciary obligation, to actually vote for the benefit of the beneficial holders.
But all this started when the SEC required institutional investors to.
It's not how it started. They were there, but in 2003 or
first was, I think the Department of Labor helped me out. But the Department of Labor,
1988,
that's right.
February 23rd, 1988. I just remember that because it's my birthday. So February 23rd, 1988, the Labor Department said, they didn't require anybody to do anything. They just said, we note that proxy voting is as much a planned asset as the opportunity to buy, sell, file a lawsuit, anything else. And so make this decision in a fiduciary way, is what they said. And you may decide as a fiduciary that it doesn't matter whether you vote, or you may decide to let the guy who manages the cafeteria checkout line at lunchtime do all the voting. That is fine. Just understand that this is a fiduciary act.
And is it?
And then it was supercharged in 2003, where they said that all institutional investors had to disclose their votes.
Yeah, I did that. I did that. And the Deutsche Bank thing was what did it. We lobbied them for 14 years to get them to make them disclose their votes. And finally, we went in and said, look at this Deutsche Bank thing. This is disgusting. And they said, you're right. This is something that investors should know. They should know how proxies are being voted on their behalf. We'll make them disclose them, but they disclose it in a very difficult way.
And let me just say what that rule said. It's intended to create greater transparency, and this will be important later, into the voting process and ensure that institutional investors act without conflicts, and that it's a fraudulent act unless the advisor has implemented policies to ensure that they vote in their client's interest.
Okay.
And this is, that makes sense. And then the proxy advisors in that same, or around that time, the SEC said proxy advisors were okay. And the economic reason why you have proxy advisors and why they make sense, so we don't disagree on whether they make sense, we disagree on some other things, is that when you're doing your analysis on any of these votes, whether it's for a board, for compensation, whatever, everybody's doing the same work. And it's very wasteful if 10,000 people do the same analysis, and because it's costly, and it's the same analysis, and there may not be benefit to any one shareholder. If I figure something out, it gets shared with everybody else. So the cost benefit is such that there's a real economic reason for the institutions to have proxy advisors, and the SEC said it was okay to use proxy advisors, and there's a real economic reason for them to exist.
Yep.
But Steve, you wrote a piece with Larker on ProMarket saying that in this market there is a major market failure. This is probably the first time that I heard you use that expression. And this is a market failure that requires regulation. So there are two new things. Number one, you recognize the market failures. Number two, that market failure automatically requires regulation. So can you explain?
Nothing on earth makes me happier.
It's the office.
Nothing makes me happier than being at the University of Chicago, my alma mater, and coming into the right of one of the economists here.
Okay, so tell us what is the market failure?
You're to my right.
What is the market failure? Why does it automatically require regulation?
I can't even, I don't know. So go ahead, sorry.
No. So tell us, what is the market failure and why, in your view, requires the intervention of the SEC? Because this is the core of what we're discussing.
So here's the issue. First of all, the SEC is already intervening, right? So the reason this exists is because of the SEC. So we're talking about what's the best regulation, because we're in a situation where there is regulation. They said they make everybody vote, okay? So that's regulation. So one thing is you don't have to vote, right? That would reduce the demand. That would actually be another solution, which is perhaps better, I don't know. But we're in a situation where you've got regulation, and now my basic goal is what's the best regulation in order to, to make the system the best there is. And let me just say, I'm gonna give a pontification here. That's a general comment. Is we're in an economy where the number of public companies is less than half of what it used to be. So public companies are disappearing. There were 7,600 in '97. There are 3,600 today. And part of the reason that public companies are disappearing, I believe, is that it is costly and value decreasing for executives and boards to be public rather than private for a lot of these companies. And so my perspective is wanting to make it less costly and less unpleasant to be a public company, but without decreasing shareholder value. Okay, so that's the perspective I have. We're in a regulated situation, and the question is, what's the best regulation? So what's the market failure? I would say this. First of all, institutional investors own 70% of the shares today. It wasn't true 20 years ago. They're usually 90% of the votes. So they're very important. The voters are substantially influenced by the proxy advisory firms. The estimates there range from 10, in some cases 25, they're up to 35% in other cases. So they're very, very, they're pivotal in some situations. And there is evidence that proxy advisory firms don't act in the best interest of shareholders. And that's what, Dave Lorker has done some of that work. I can cite you a lot of that work. There's evidence that some of them, ISS in particular, is ideological, which again is, speaks to not acting in the best interest of shareholders. There's a huge lack of transparency. So, you advocate transparency for auditors, transparency for directors, you have to disclose all sorts of things. The proxy advisors don't have to disclose anything, and the issue there is that at least one of the big ones consults to the corporations that they're then voting on. And if you talk to people, I heard twice in the last week stories of being shaken down, where, in this case was ISS, disapproved of somebody's, comp plan. And the company said, well, how do we make it better? And they said, hire us as a consultant, put in our software, and then we will help you. So what this, so conflicts are there, they matter, and that's something to think about. It's hard to correct mistakes under the current regime, because what happens is the proxy advisor will put in its recommendation, and again, they're controlling up to 35% of the votes. The recommendation comes out, the shareholders vote immediately, and if there's a mistake, the company doesn't have a chance to change that mistake. And I've heard this a number of times. You see this, people have written this, even shareholders, Blackrock, I think, complained about this, is that it'd be good if you had time to have some discussion and correct the mistakes. And then, the last part is corporations are influenced by the proxy advisors. So they know the proxy advisor is influential, so they change what they do in order to make the proxy advisors happy or to get a good vote. So what's the market failure? In a normal market, you get competition and you have some people doing different things. That doesn't seem to be the case here. The top two firms have 97% of the market. They've had a big share of the market for a while. That doesn't seem to have gone down. And the institutional investors, for the most part, don't have an incentive to switch or do the work themselves. And so, at the end of the day, what do you conclude? And this is, I'll rely on Chester Spatt, who was the chief economist at the SEC at one point, and is not particularly ideological that I know of. And he concludes the evidence indicates that proxy advisory firms are oriented to maximize their own value rather than the shareholder value of the companies for which they're making recommendations. And so, at the end of the day, I look at that and say, well, maybe we can change the regulations and make them better. And I think the SEC's rules, and we'll talk about them more, make them better, they're improvements, and that's why I was in favor of them.
Thank you, Steven. I know that you're going to also support regulation of Google, who has 80% market share by itself. So I'm going to the same logic. We're going to go there, but this is for another discussion. I want to ask now.
Yeah.
First of all, can you give us, because we went so much into the topic, and many of the audience probably don't know the details. So can you tell us what the SEC is proposing to do, and then why you think that it's, I think, wrong?
Well, first, I really want to thank Steve for being here, because I want to say that he's extremely brave. A lot of what he said was wrong. A lot of what he said was wrong, and I'll tell you why. But he's extremely brave. And I was originally invited here to debate the SEC commissioner who is in charge of this rule, Commissioner Weissman, and he bailed when he found out that I was going to be here, which is really kind of understandable when you consider that the whole purpose of this proposed rule is to protect CEOs from any criticism. So he doesn't like criticism, he wants to keep CEOs from any criticism. Let's talk about a business school case study for a minute. We've got a product nobody has to buy. Numerically, more than half of investment managers do not buy it. The big ones do, but it's expensive. They produce research and recommendations nobody has to follow. First thing he said that was wrong was how persuasive they are. Yeah, they're very persuasive when they say vote for the unopposed board of directors, vote for the auditors. They're super persuasive on that. But to the extent that anything departs from that, shareholder proposals, CEO pay, ISS, for example, recommended votes against 13% of CEO pay packages, which I think is fine. If you can't recommend against the bottom 13%, what's the point of even putting it to a vote? The actual vote, however, 2%. So that shows you that their clients, the most sophisticated financial professionals in the world, look at the recommendation, look at the analysis, and come to their own conclusions. I trust the market. I don't trust Professor Larker, who has corporate-funded research made to order. I trust the market. I trust these sophisticated financial professionals to decide the value of the proxy advisors. And if they think it's useful, they look at the information. They don't necessarily follow it when they don't agree with it. Then I think we've probably got a pretty good system. Furthermore, guess what? No barriers to entry. Anybody wants to start a proxy advisory firm, I'll be happy to show you how it's done. It's much easier than when I started it, because we had to do everything on paper. All the proxies were on paper. We had to print out things and mail them to people. You don't have to do that. You can just scrape the data right off. By the way, the error rate for ISS, less than 1%. I would challenge any of the companies that they provide advice on to come up with a 1% error rate. Of error rate as documented by corrections they actually had to issue, instead of some things that are called errors but are just disagreements about policy.
No, but let's be honest. It is true that it's free entry. It's also true that, as Steve said, this is a job that has enormous economies of scale. So it's not that easy to have a really competitive market. And so Steve, who is very sort of pro-antitrust enforcement, would like to bring some sort of enforcement here, because there is maybe excessive concentration.
Transparency. I'm just asking for transparency.
They have plenty. In fact, ISS every year, because they do, guess what? They are a commercial enterprise. They do want to maximize their profits. So one thing they do every year is they go out to all their clients and they say, what do you think of our policies? Are there any policies you'd like us to change? And then they change them because the clients want them to. Not only that, some clients actually subcontract ISS, have them vote the proxies, and they say, here are our policies. They're not the same as yours, but vote them according to our policies. And ISS does that too. ISS either bought or beat much of its competition. People do enter the market. ISS, like a good commercial enterprise, bought or beat a lot of it. And there was a third player, or I should say a fourth player, who had a terrific product. And they failed. You know why? It was founded by a former commissioner of the SEC. Because they were funded by the Business Roundtable and nobody trusted anything they did. Hooray for markets!
But I still don't understand what you have against disclosure. The SEC rule, let's be clear about what it says. It says simply the proxy advisors have to disclose conflicts to their clients they don't even have to do it publicly, which, by the way, I think doesn't go far enough. I think you should
I'm fine
have
with
to
that.
disclose.
They already do it, by the way. ISS already does it. And if you don't
But
like
they already
conflicts,
do?
if you don't like conflicts, go to Glass Lewis. They don't have it.
Glass Lewis doesn't have conflicts.
Okay,
ISS,
there you go.
but ISS,
Market,
so
they're
why are
wonderful.
they not? Why don't they disclose their clients publicly? I think that's not true. I
They
have an
do, yeah,
example.
actually they do. They do. So, but, you know.
Their corporate clients.
They just publicly?
They
Why do they do that?
they say in their contract.
But when they have a proxy, when they send out their proxy advice, they disclose whether the company they're advising on is a client.
So why would you not have? Why don't you like the SEC rule then?
I don't care about that part. What I care about is
Okay,
the
so that's
Constitution.
So we have another point of agreement, that they all agree on all these
They're already
I
doing
think-
it. They're
because
already-
it is-
But what about
Steve, I
people-
would go even farther. I would say, why don't we forbid them to be in the business of consulting?
Well, they
Because
do
that-
that with
that-
auditors.
When I was the
No,
president-
they don't do it all the
No,
time.
I'm saying,
Yeah.
right.
When I
But-
was the
but yeah, they
president
should do
of
that,
ISS,
yes.
I did not allow consulting when I was the president.
Yeah.
But in fairness to ISS, and I still don't agree with it. In fairness to ISS, there were a bunch of nitwit consultants who would then go to these companies and say, I will sell you information about how to get along with ISS. And they were giving them bad advice. And companies were calling us and saying, it's not fair that you are recommending against our pay plan, but not telling us how to fix it. So I understand why they do it. But the point is, if you don't like that, you don't have to do it. Here's, the proposed rule is actually unconstitutional. I attended the law school at this very university, and I know for a fact that the First Amendment prohibits prior restraint. This is a rule that is proposing requiring ISS and Glass Lewis to send their draft proposals out to the company before they go public with it. That's ridiculous. That would be like telling the Washington Post or the Chicago Tribune that they have to send the newspaper out to political candidates before they publish stuff. That's not a thing. You're not allowed to do that. It's unconstitutional. Furthermore, ISS voluntarily does that for the S&P 500.
But, okay, so the point is important because otherwise it gets lost. The SEC proposal, what they do is they require the proxy advisors, besides the transparency, we all agree, they
So
require the
we
proxy
agree on
advisors.
conflicts of interest.
Yeah.
Okay, very
So
good.
they require to send their opinion to the company and wait for the company to get back and reply with some arguments to the company a second time before releasing the advice. Now, this seems to be a minor thing. Little detail, time is of essence in this business. Why? Because you have only 45 days between generally when the shareholders meetings is announced and when it's voted, and they promise to give their clients enough time to sort of review this, so they promise to give everything 2 weeks in advance. So now you're in a situation in which if you agree with a company, you know the company will not have any objection, you can go fast. If you disagree, you get into a fight, and that is more costly and more time consuming. And the problem is that all the proxy advisors take place at all the proxy fights that take at the same time. So if you're in the business, imagine the business model of these guys. They need a lot of qualified employees between March and June, and by the June, they should fire everybody. So it's not a very viable business, and what the SEC is doing is increasing this cost in an asymmetric way. So why you love this idea so much, Steve?
So the reason for this idea, and there's a trade-off, is companies, as I said before, they get the recommendation from the proxy advisor, or the proxy advisor makes the recommendation. The shareholders vote immediately, most of the shareholders. And some of them are, I think the proxy advisor actually doing the voting for them. Then, if there is a mistake, or if the company disagrees, they basically have no recourse. And I can tell you, sometimes the company makes mistakes, and I can give you examples of a company making a mistake which you want to correct. Sometimes ISS or Glass Lewis make mistakes. And the SEC rule is basically, let me just get it exactly right. If you put out your proxy statement, I think it is 45 days in advance of the annual meeting. So it's not like they're giving them no time. They thought about this, that there's a 45 days before the shareholder meeting. the proxy advisors got to give feedback at least 5 business days for review and feedback. That seems perfectly reasonable. And about it being illegal, you know, when a company every quarter does its financial statements, it's negotiating with the auditor. The auditor is giving them information, they're giving it back. Takes a lot more than 5 days, but that's sort of a normal business thing.
It's not a First Amendment issue, because it's not an independently published, it's not an independent publication that is not,
I'm not sure about the legality. Yeah. I'm not going to argue about legality, but in terms of the economics and the fairness,
I've got a question. I got a question for you, Steve, which is I'm as deeply committed to transparency as you are. So what about the fact that 7 comments cited by Chairman Clayton when he announced this proposed rule as coming from individual investors who were so vitally concerned with this very arcane issue of proxy advisors? What about the fact that, as Senator Van Hollen said to Jay Clayton in a Senate hearing, he was duped that the 7 comments that he cited all had the same typo in the address of the SEC, and when Bloomberg called the purported senders of these comments, none of them had ever heard of them before, but some of them were relations of the K Street lobbyist that was working on this. There's also a new video. There's also a new video on YouTube by a Republican operative who does not disclose herself as such and doesn't say who's paying her, who says, are you ready? This is the trifecta. She says everyone should write in to support this rule because otherwise you are supporting abortion, open borders, and gun control. Plus, she says, these are all mom and pop corporations. They are not. They're all big public corporations. And she says the people who support the rule don't have real jobs. I have a real job, and I don't support the rule.
I have a real job.
So,
there's bad behavior. Blackrock basically put out a paper in I think November 2018, basically agreeing with all these things. So there's bad behavior there, but you have someone like Blackrock who is, you know, I think well thought of in terms of providing good governance.
They don't want to have a second opinion. They want to decide themselves. So if there's somebody conflicted here, it's Blackrock.
Should a rulemaking proceed based on clearly fraudulent, and this is what, when he was told he was duped by Senator Van Hollen, Jay Clayton responded, it doesn't change the underlying reality. Yeah, actually it does. That's what duped means.
But anyway, let's go back to the substance here. And I think you make, and I don't want to get into the legal advice, but I want to make a comparison. And it says, you said, it's a business with enormous economies of scale, which is very influential, and is an oligopoly, and in a sense, you should have responsibility for what you say. Now, the newspaper business is pretty similar. There's enormous economies of scale. Now it's getting oligopolistic. The New York Times is very influential on people's votes. So why don't you go and say that the New York Times is liable for every mistake they make?
So wait, now you're moving again to a different thing. We haven't gotten to the liability part. We're just talking about that you have to have a discussion.
Okay, let's start with the discussion.
Reporters all the time, and I think good reporters, when they go to a company, they actually get feedback from the company. When they're doing an expose,
are they required by law to show all the articles to the other side?
They're not required by law.
And I think, so you're advocating that they should be required by law?
This is something where it's regulated to begin with. This is the distinction.
It's not regulated. Over half of numerically, over half of investment managers do not buy any proxy advisory service.
The SEC has regulated that you have to vote. And this is just saying
you have to vote. We're not getting proxy advisors.
You don't have a proxy advisor.
They've allowed you to have a proxy advisor. That's part of the regulation. They could have said no proxy advisors.
And over half, numerically, do not use a proxy advisor.
I'm not sure that's the case of the S&P 500. I'm not sure that's true of the S&P 500. I'm not sure that's true.
So in many countries, people are required to vote. Okay, it's a regulation. Yeah. And they need to get informed, so they buy the newspaper. So the argument applies in the same way. So you are in favor of saying the newspaper should disclose all their things,
I
and
don't,
need
I
5 days.
I'm just not gonna grant that as an analogy.
It is an analogy. It's an independently produced publication, the sole source of independent research on proxy matters that no one has to buy, with recommendations nobody has to follow. It is a publication.
But let's go back to the liability, because while it is not at the essence of this particular SEC ruling, the SEC has decided that the proxy advisor opinions are not opinions according to general term, but are proxy solicitation, and this leads to a risk of a liability suit. So now it is as if you are like a bit in Singapore, that if you sort of write something against the government, you are not put in jail, you are sued for an enormous amount of money that brings everybody to bankruptcy. And it seems that that's kind of the path for this proxy solicitation, because if you say in favor of a company, no chance you're sued. If you say something against the company, there is a small chance of being sued by the best lawyer in the country, most finance. So basically, if I am a businessman, I would never advise, as a proxy guy, to say anything negative about the business.
So this one is a more mixed. This one is I think harder. The having more disclosure and allowing the companies to go back to the proxy advisor seems very hard to argue. On the litigation, on the being able to sue somebody, there, I think you can make an argument both ways.
How many legs does a cow have if you call a tail a leg? The answer is 4, because calling a tail a leg doesn't make it one. They want to call proxy advisors proxy solicitors, but they're the opposite. Proxy solicitors are hired by the company, paid with the company's money, to advocate for one position, not to provide both sides. Proxy advisors, as I said before, produce product nobody has to buy, bought by the most sophisticated financial professionals in the country, and nobody has to follow their recommendations. They're not proxy solicitors, and this rulemaking calls them proxy solicitors. It's calling a tail a leg.
I think the idea behind the rule is to make sure that their methodologies are sound and that their data are sound.
And the best people to decide that are their customers. That's how markets work.
Again, that's where you have to worry
You're
about
the
the fact that
state.
there
You're
are
advocating for the
I
state.
am advocating for more disclosure and
I
ability.
feel so sorry for the sophisticated financial professionals who all have MBAs from places like this.
Can I give you one story that also should give you pause? Maybe it probably won't, but there was a PhD, and this is about the actual, goes to the point of whether the clients of, this is ISS or public, there was a PhD student a few years ago who was able to get information on the clients of ISS, corporate clients. And he was working on his dissertation, and he wrote a paper where he looked at ISS recommendations. He controlled for many things, including Glass Lewis's recommendations. And he found that if you were a client of ISS, your votes, the likelihood that ISS would approve your proposal was like 6% higher. And that rule or result was greater the more you paid ISS. Now what happened? You don't hear about that paper, because after he wrote the paper and he put it up on SSRN, ISS made him take it down. And they also made him say he would never present that result. I know about it because he did put it up, and he did actually submit it to this school on the job market. And so it's kind of funny that if they believe in transparency and they believe in disclosure, that they pulled this, number one. Number two, in their contracts with corporate clients, ISS, at least the last I saw, doesn't allow the corporate clients to say they hired ISS. So I'm looking at this, and again, going back to this thing about whether the proxy advisors are maximizing their value or the value of their customers, I think is a real question. And that's where part of the SEC
Yeah.
proposal that I like on disclosure
Uh-huh.
and allowing the company to have a discussion seems
I'm
perfectly
100%
reasonable.
confident in the capacity of the largest fund managers in the world to evaluate ISS and decide whether to buy the product or not, and to bake in some skepticism about the ISS recommendations, which they seem to be doing, as evidenced by the statistics I've already given. I do not want the nanny state making that decision for them. I'm all in favor of transparency. I didn't allow ISS to do consulting when I ran it. It had 25 employees then. It is now a big multinational corporation. Let them do what they want to do. Let the market sort it out.
So I'm going to open for questions in a second, but before I do that, I want to ask you, both of you, one last question.
Okay.
So let's consider an alternative scenario. I imagine that both of you are in favor of involving shareholders more in the decision and having more voice to shareholders. So one simple way, because I think the fact you mentioned, Steve, is very important, that 70% of the stock is now owned by institutional investors. So people like Blackrock end up having a disproportionate power. And I'm always worried when power is too concentrated, because power corrupts and absolute power corrupts absolutely. So I have this alternative proposal. Why don't we require that when you subscribe to or invest in a mutual fund, you as a shareholder or in the mutual fund can choose how your votes are going to be casted depending on the proxy advisor of your choice. And that opens up the market, because now there'll be more variety, and will be full transparency, and that seems to me the best of all worlds. But I'm sure I've not thought this enough. What do you think of this idea, Steve?
So explain this again. So as individual.
Yeah, as an individual. So you, Steve, is investing in a particular fund. Let's say
I can choose my proxy advisor?
Yeah.
Again, I mean, you kind of have that now with the institutions, and this is where I'm a little puzzled by Nell's comment. The places or the institutions where the proxy advisors seem most influential in the research is the smaller the smaller institutions, not the big ones. The big ones, like the Blackrocks and the Fidelities, they vote the way they want to, and they do their own work because they can, they can afford to, and it makes a difference. The place where the proxy advisors have the biggest influence are with the smaller institutions, and so, to the extent that a mutual fund investor is like a really small institution, I'm guessing the same thing would happen. You'd have a couple of big ones. They have no incentive to be informed. They're not going to know. So I would be skeptical. Would you try that? Again, that doesn't seem unreasonable to me. I'd have to think about it more. So it doesn't seem unreasonable to me. I don't think it would affect the outcome. So.
What I would rather see, that's fine with me if somebody wants to put that on the market, I wouldn't require it. You can sell pizza flavored toothpaste and see if anybody wants to buy it. I think that what I would rather have, the reason that we pushed so hard for 14 years to get the SEC to make mutual funds disclose their proxy votes, is so that consumers like you could go in and say, an index fund is an index fund is an index fund. They're all going to have the same returns and the same fees. But maybe if I have a choice between one that votes against outrageous pay plans or in favor of shareholder proposals on climate change, then I'll pick that one. So I think that that's the way, again, I would defer to the market, let the market decide. Let me also say that all these shareholder proposals that we talked about, which are the ones that the companies are really upset about, and that's why they're promoting this rule, they're non-binding. Even 100% vote doesn't bind the company. So if 100% of the shareholders come in and say, yes, we agree with the shareholder proposal that you should write a paper about climate change, the company can just blow it off. So the risk is very small, in my opinion. The cost is very small of keeping the system the way it is.
Okay, so we have still 10 minutes for questions. Doug, you're first.
Okay.
The microphone is coming.
Thanks. So one of the points that Nell has made fairly forcefully is that large institutions have their own resources to do this research, but a lot of the large institutions are facing pressures. We've got passive, we've got fees on mutual funds essentially going to zero So a lot of even the large institutions, and I know, some of the graduates of this school who run some of these big shops, they're essentially doing away, they're removing all of the costs they can. One of the things they're doing, and this is fairly powerfully shown in the academic research, is that they're outsourcing the research to these firms. So one of the arguments, I think, on Steve's side of this is that these firms actually don't have their own research anymore that informs the votes, and that they just rely on ISS and Glass Lewis. Now,
That's not what the data show in terms of how their votes depart from the ISS and Glass Lewis recommendations.
well, I think the academic research shows that these entities do have an effect on shareholder votes.
No, the research is, as
Oh,
Nell
yeah.
and I said, that it has more, at least historically, the ISS and Glass Lewis recommendations have more of an impact on the smaller investors rather than the bigger ones. Now, what you're saying is, going forward, to the extent that the big ones even come under pressure, they may do less of their work and outsource more of it, which would make the problem worse. And again, the problem is, which now is really not addressed, is there is a lot of evidence that the recommendations that these firms make don't maximize shareholder value, in fact may destroy it, and it's very hard to analyze it. One of the things that the SEC is asking for is just more disclosure of the methodology and what they're doing, so you can actually test whether they are maximizing shareholder value. And again, I find that completely unobjectionable. They ought to have.
I don't agree. I don't agree with your statement that the research suggests that the
Some of the research suggests.
some of the research suggests a lot of that research is funded by corporations, and I would rather let large financial institutions led by professionals and subject to the highest legal standard under our legal system,
I don't have a
fiduciary.
conflict here. I don't
to-
know. You keep talking
Yeah.
about corporations. Corporations are not funding me.
No, but they're
Next question,
and nobody's funding me, by the way. I'm not getting paid by anybody for any of the advocacy I'm doing around this issue.
Now, I have a follow-up question on this point. One of the allegations to Proxy Advisors is to have a political agenda. So they want to stop climate negative measures just because they are afraid of climate change, or they prefer more equality in the board instead of all-white board and so on. So the question for both of you is, do they have the legitimacy to have this kind of preferences? And if these are like political or social preferences, how can we expect that they maximize shareholders' value? I mean, the Business Roundtable in August said that the purpose of corporation is not to only to maximize shareholders' value, but they have to take care of all the stakeholders. So if we ask them to disclose the methodology to prove that climate change is a bad thing, maybe it's a bad thing for society, but not for an oil corporation. So how do we reconcile all this?
I would recommend that you read a sample analysis of one of those issues from ISS, and you will see how thorough and documented it is. But again, I would rather let the investors decide whether there's a financial benefit to voting a particular way than let Steve decide or the SEC decide.
And again, I'm saying, I'm putting in, saying there's an issue that there are only two players, and it's very hard, given the economics, to imagine there won't just be those two players. And given that, how do you make sure that there is more transparency and that
You don't go after the proxy advisors.
These things are saying disclose more. Most of
No.
what is in here is disclosure and allowing
Anybody who
companies.
is voting badly, go after them. As far as I know, in the history of this country, the SEC and the Labor Department have never gone after a money manager for voting improperly, for voting contrary to the interests of the shareholders. That's who you want to go after, don't kill the messenger.
But then if they haven't done that, then the litigation point that you made is also a non-starter, because it is very infrequent that you see people sued or litigated on these issues, particularly if they're dotting their I's and crossing their T's. So that was, I think, contradicted a little bit what you said earlier.
No?
But Steve, I'm with you on the concern that this is too concentrated market, but increasing the cost for them is going to bring the market in more concentration. It's going to go in the wrong direction, because if you have all this back and forth...
It can't be worse. I mean, it's
it's worse than two.
I think it's highly unlikely, given what these things say, in my opinion, because it is, you've got the two here, and I think on the margin, the disclosure issues, the conflict issues are stronger for the player that's bigger, so I think that's highly unlikely.
No, but not the disclosure part, but the one that entertaining back and forth with the company, that increases the running cost. And I think the marginal delay is going to get out.
It's going to increase it hugely.
Yes.
This is where I disagree. It's like, 45 days before, they hire lots of temporary people for the reason you said, which makes you, again, have a concern. Are they actually doing the right analysis? So on the proxy, but people have to buy their product for economic reasons. This is where the SEC, by the regulatory reason, by saying you can outsource this, and the economics are compelling to outsource it on the day-to-day things, which is the thousands and thousands
So
that
you
have to
favor
do.
the SEC saying you cannot outsource this?
No, I think the SEC, if the SEC said you didn't have to vote on everything, that would be another solution.
They never said you have to vote on everything.
They effectively said you have to.
They effectively, well, they didn't say you have to. They said it's a fiduciary act just like everything else that you do with a share of stock is a fiduciary act. So let them prosecute those who do it badly.
So maybe I make an amendment to my proposal. You let the shareholders say, you don't have to vote for me. But then if you vote, you choose this proxy advisor.
There's a huge collective choice problem.
I mean, that's the issue with all of that.
How
There are all these collective
would
choice
you feel in
problems
your
under
board
that.
meeting if they say you didn't get a quorum? We didn't get a quorum, so there was no vote this year. So we're basically out of
He's going to be elected anyway, so it doesn't matter.
I'd like to move to a conversation about the going concern, which we've not gotten into in this conversation. In 2018 and 2019, Hertz's board turned over the entire management team due to their mismanagement of a strategy consulting firm. And once they turned that over, they then filed a lawsuit against that firm, Hertz versus Accenture. What are your opinions about this issue? And just like Steve said, if there's a conflict of interest with the voting, there's a conflict of interest if your strategy consulting firm has been on site for 15 years straight.
Steve, what do you think? Do we want McKinsey to disclose all the jobs they're doing? Require the SEC to do that? I think that's an excellent idea. I will make a proposal, I want you to sign.
If that's a shareholder proposal, I endorse it.
That's not being regulated. That's the thing. The voting is being regulated, and this is a tweak to the regulations that I think is an improvement. The consulting and what you do as your business, I think that's a little bit different.
Okay, one last question. Okay, I think everybody's been satisfied. Let me thank you enormously both Nell and Steve for this fantastic debate. Thank you very much.